Contempt of court. In this presentation, we will discuss about what is contempt of court. In a democratic society, what will be the meaning of contempt of court, what constitutes a contempt of court, how to understand that. These many things we will try to understand through this little presentation. Rule of law is the basic rule of governance of any civilized democratic polity. It is a foundational feature of a constitution, and the right to obtain judicial redress is a feature of basic structure. Judicial independence is one of the facets of rule of law. Rule of law is nothing but rule through the democratic constitutional governance. So, that is the basic through which we have been governed. If you want to establish that, then rule should be the supreme, which means that judiciary should be the supreme. That is a basic idea on which the contempt of court is being operated. It is through the courts that the rule of law reveals its meaningful content. Protection of the administration of justice is therefore a imperative, as it is existence to the civilized functioning of any free and egalitarian social order. So, the rule of law reveals the meaningful content. The law of contempt secures public respect and confidence in the judicial process and provides the sanction of any act or conduct which is likely to destroy or impair such a respect and confidence. So, contempt operates on two principles. One is to secure the respect and confidence. Only when the court gains the respect and confidence, it can maintain the supremacy of the rule of law, for which it sanctions something which will help to maintain the supremacy of the law. Now, we will move on to understand what are the examples of contempt of court. What can be called a contempt of court? I have about 6 examples through which you can understand what is a contempt of court. Number 1, assaulting anyone in the court. If somebody is assault the court functionaries or officials, then it is a contempt of court. And insulting the judge in the court, and somebody by reference of words or gestures or by writing or by giving any kind of symptoms or signals to the court that judges being not respected, then it is a contempt of court. Number 3, throwing something on the clerk. You can't just imagine that a clerk is a very inferior position who cannot be called a part of the judicial system. That is not the case. In the entire court, if there is an official called clerk is sitting there, and if you are throwing something, that is a contempt of court. Number 4, wearing offensive clothing or not wearing any clothing at all in the court. If somebody is wearing something that is not acceptable in the court, then that is called contempt of court. Or somebody is not wearing properly or fully not wearing, then that will also be a contempt of court. Number 5, refusing to answer a question when ordered to do so by the judge. When the judge says that do this or do that, then if you are refusing that, then that is a contempt of court. The 6th one is creating a disturbance elsewhere, such as in the corridor outside the courtroom, so that the court hearing is disturbed. So, not only within the space of court, you are sitting somewhere outside and you are talking to your friend, then that disturbs the proceedings of the court, then that will become contempt of court. So, these many things, these 6 examples probably would give you an idea of what constitutes a contempt of court. The power of the court to punish the contempt, that we have to understand that. What will happen that if somebody is violating and become doing the contempt of court, what will happen then? The power to punish for contempt anyone who interferes with the administration of justice is an inherent power vested in the judiciary. So, when the judiciary process is being disrupted, when the judiciary is being interrupted in the form of any form, then that will be punished by the court. Let us see what is a civil contempt. Civil contempt of court provides for punishment of a person who refused to comply with the orders of a court. Consequential sanction will be committed to prison or fine. So, when you are refusing to oblige or obey the orders of the judge, then that will become a civil contempt, for which somebody will be put behind the bars or they will be given with the fine of something. When you talk about civil contempt, then obviously the next one is criminal contempt. So, what is a criminal contempt? Criminal contempt includes any kind of interruption or interference in the administration of justice in or out of court. This is being stipulated in the act called Contempt of Court 1971. The jurisdiction to punish for contempt touches upon two important fundamental rights of the citizen, namely the right to personal liberty and the right to freedom of expression. The Contempt of Court Act has been devised on two principles of fundamental rights. One is on the freedom of expression and the other one is personal liberty of an individual. As a citizen, that we have entitled for personal liberty, as a citizen we are entitled for freedom of expression. So, on these two grounds only that the entire act has been constructed. A committee was set up in 1961 under the chairmanship of H.N. Sanyal, the then additional Solicitor General. The government accepted the recommendation of the Sanyal committee and the new act of Contempt of Court Act was passed in 1971. Actually, we had a different Contempt of Court Act previous to the 1971 Act. There was no definition of contempt of court at all, whether it is a civil or criminal contempt. That was not defined in any of the earlier acts called 52 Act or 62 Act. Only in 1971 we started to define about what is contempt of court and how it is can be understood as whether it is a civil or criminal one. The Sanyal committee recommendations also did not contain any definition of civil or criminal contempt. The Constitution of India, if you look at the Constitution of India, there also we cannot find any kind of reference about definition of contempt of court. Let us try to understand the definition of contempt of court. There is somebody called Oswald. He defines contempt of court, tries to make us understand about what amounts to contempt of court. According to him, any conduct that tends to bring the authority and administration of law into disrespect or disregard, to interfere with or prejudice parties or their witness during litigation is considered to be the contempt of court. So, he made it very clear that whether at the process of law or process of inquiry, at any level, any kind of interference in the jurisprudence will be amount to contempt of court. Contempt of court is also defined by somebody else called Halsbury, who says that as consisting of words spoken or written which obstruct or tends to obstruct the administration of justice is called contempt of court. Let us try to understand what is civil contempt. There is a specific mention in the Contempt of Court 1971, that is called section 2B of the Contempt of Court, which defines what is a civil contempt. Civil contempt means willful disobedience to any judgment, decree, direction, order or writ or other process of a court, or willful breach of an undertaking given to a court. So, whether you are willfully or knowingly disobeying the orders of the court, or you are undertaking whatever that you are given to the undertaking to the court, if you are willfully violating that breach will be called contempt of court. And civil contempt occurs when a person disobeys a court order and is subject to sanctions such as fine or imprisonment. When you are not ready to obey the court order, that becomes automatically a civil contempt. The purpose of civil contempt is not only to enforce court orders, but also to maintain public confidence in the judicial system. Two essential constitute for civil contempt. First one is disobedience. When somebody is disobeying court judgment, decree, direction, order, writ or other process of a court or an undertaking given to the court, then that amounts to contempt of court. The second one is disobedience or breach must be willful, deliberate and intentional. Just a mere disobedience, a breach of the court's order by the person is not sufficient to constitute civil contempt. Such a disobedience or breach must be willful, deliberate and intentional. And in order to exercise its power to punish the contempt, the court has to be satisfied beyond reasonable doubt that the contempt has willfully, deliberately and intentionally violated the court's order. So, if somebody is to be punished under this, then the court authorities or the judges should have the satisfaction that this is not a mere contempt, it is not a mere violation, but this has been done with the intention of or the willfully and knowingly done that. According to section 2C of the Contempt of Courts Act 1971, criminal contempt means the publication, whether by word, spoken, written or by signs or by the visible representation or otherwise of any matter or the doing of any other act whatsoever it is, that will amount to criminal contempt. And it defines further that number 1, whatever that scandalizes or tends to scandalize or lowers or tends to lower the image or the reputation of a court, that can be called criminal contempt. Number 2, prejudices or interference or tends to interfere with the due course of any judicial proceeding, and interferes or tends to interfere or obstruct or tends to obstruct the administration of justice in any other manner. Criminal contempt occurs when there is interference with or disruption of criminal or civil court proceedings, whether it is civil court proceeding or criminal court proceeding. If you are interfering in that, then that will amount to contempt of court. Publishing matters not only about interference in this way. If you are criticizing through media, through prejudiced writing, that will lead to a kind of disturbing the fair trial of the court. Criticism of courts or judges which may undermine the public confidence in the judicial system is called scandalizing the court. So, if somebody is trying to scandalize in the court, which is trying to undermine or lower the image of the judges and judicial system, that will amount to contempt of court. There are 4 important essentials to constitute a criminal contempt. Number 1, publication of any matter. Whatever that you are publishing that interferes with the court proceedings will be called contempt of court. Number 2, scandalizing or lowering the authority of the court. If you are trying to scandalize the image of the court or trying to lower the authority of the court, then that will lead to the criminal contempt. Such a conduct is punished as tends to create distrust in the minds of common people and thereby shatters the confidence of the people in the judiciary. Number 3, prejudice or interference with the due course of any judicial proceeding. Innocent publication and distribution of matter. Fair and accurate report of judicial proceedings, fair criticism of judicial act, bona fide complaint against the presiding officer of a subordinate court, justification by truth. The truth is now a defense if it is in the public interest and bona fide. Automatically, these are all called defenses against the criminal contempt. Defamation of judge personally, if the publication or other act is merely defamatory attack of the judges and is not intended to interfere with the commission of administrative justice, it will not be taken as a contempt of court, which means that you are trying to understand or criticizing a judge based on the delivery of justice system, then that won't be called contempt of court. And there is some remedies are available against the order of punishment. You have done something, written or publishing something, and if you want to evade from that, then there are some procedures available. We will see one by one. Number 1, you can go for apology, which means that the contemner, the people who have condemned the court, may under apology to the court, and the court may remit the punishment awarded by for the contempt. If the court satisfied that the apology has been made with a real sense of repentance. Second one is appeal. You can go for either apology or you can go for appeal. Contempt of Court Act 1971 has provided for the statutory right of appeal against the orders of High Court passed in the exercise of the jurisdiction to punish or the contempt of court. While understanding the contempt of court, one should be knowing about what is sub judice rule. Let us try to understand through some examples and definitions. In common law jurisdictions, one of the significant role of contempt of court law is the application of the sub judice rule. No one should interfere with the legal proceedings which are pending. This is to prohibit the publication of matters which are likely to prejudice the right of a fair trial when legal proceedings are pending, or a more colloquial sense, to prevent trial by media. So, no one should interfere. You cannot conduct a parallel trial by call it media trial. To have a fair trial, the court prevents the media system to publish anything that is under the fair trial. This is called sub judice. For instance, possible violation of the sub judice rule is a publication which abuses or pressures a party to a proceeding to the extent that he or she is deferred from attending court. You are writing something which differs, which avoids a person to go for the court proceedings, will nothing but called sub judice. We will see one of the classic case of Nambudiri Bhat. It was an old case, but even then you might be knowing about, you can understand what amounts to contempt of court. Namboodiripad was the Chief Minister at the time, and the case is called EMS Namboodiripad versus T.N. Nambiyar. The Chief Minister of Kerala made a public statement accusing judges of class bias. He made it very categorically accusing the judges called a class bias. And I read the actual statement of Namboodiripad, which will give you an idea of what amounts to contempt of court. Marx and Engels considered the judiciary an instrument of oppression, and even today it continues so. Judges are guided and dominated by the class hatred, class interests and class prejudices, and where the evidence is balanced between a well dressed pot bellied man and a poor ill dressed and illiterate person, the judge instinctively favors the pot bellied farmer. So, the Supreme Court upheld the conviction for the contempt of court, reasoning that the likely effects of his words must be seen, and they have clearly the effect of lowering the prestige of judges and the courts in the eyes of the people. So, that was the judgment of Supreme Court that explained that even if you are Chief Minister, you cannot utter or you cannot express motivation to the judges, and you cannot call them class biased. So, Namboodiripad was punished, and that was even upheld by the Supreme Court of India. This presentation tried to make you understand about what is defamation, what is contempt of court. We started with understanding what is defamation through Shakespeare's quote, and we also discussed about what is civil defamation and criminal defamation. We moved on to understanding the contempt of court through the Contempt of Court Act 1971, and we ended the lecture with a popular violation of contempt of court by a popular Chief Minister of Kerala, who actually been convicted on particular case. Hope this presentation would have given you a larger picture about defamation and contempt of court. Thank you for viewing the lecture.